if a picture says 1,000 words, then a surveillance video can be priceless. Nowhere is that more the case than in Michael Irvin's $100 million defamation case against Marriott Hotel and the Jane Doe employee at the hotel who has accused him of improper behavior while staying at the Renaissance Hotel in Phoenix. That got Irvin pulled off of the air, canceled from the NFL Network's Super Bowl coverage. Irvin originally filed his defamation lawsuit in a state court in Texas on February 9th, alleging that the manager of the Renaissance Phoenix Hotel tried to cancel him by recklessly reporting to the NFL that he had engaged in misconduct with a female employee. On February 16th, Irvin's lawyer filed a motion for expedited discovery in state court. Here you can see the February 16th motion for expedited discovery filed in the state court by Irvin. And let's skip forward to the highlights down here in paragraph 2.06, where it says, despite plaintiff's diligent efforts, he has been unable to ascertain who specifically made these allegations and why they were reported to the NFL without any confirmation by the hotel. It's a really good question. Defendant's actions and refusal to release requested information have made it impossible for plaintiff to clear his name. Irvin is requesting request for production number 1, any and all video recordings, written reports, and or witness statements gathered that pertain to Michael Irvin's stay at the Renaissance Phoenix Hotel and Spa in February 2023. In interrogatory number 1, it asks for Marriott to provide the name and contact information for any and all of defendant's employees who made a complaint against plaintiff Irvin. It's asking for contact information and name of employees who alleged to have been offended by plaintiff Irvin's conduct. Then he's asking for name and contact information for any and all employees or managers who contacted the NFL about plaintiff Irvin's conduct. And then finally, he's asking for the names and contact information for any and all persons associated with the NFL to whom reports were made regarding Michael Irvin. And then he's asking the court to order Marriott to produce this material and these answers to the interrogatories by February 20th at 5 p.m. That same day, the state court judge in that case actually granted the motion and ordered that Marriott produce all of the information and document surveillance footage that Irvin had requested without even waiting to hear from Marriott in response to it. Let's briefly take a look at the court's order and what it ordered Marriott to produce that day. Here we have the state court's order on plaintiff's motion for expedited discovery. As you can see, it was entered at 11:50 a.m. on February 16th. Just seems like just hours after Irvin had even filed his motion. So certainly Marriott didn't have a chance to file a response to the motion before the court just simply ordered Marriott to respond to Irvin's requests. The order states that defendant must respond by 5 p.m. on February 20th, 2023 to Irvin's request for production and interrogatories described in plaintiff's motion for expedited discovery, to wit. And then the judge copied and pasted Irvin's various discovery requests right here. Just hours before its 5 p.m. deadline to produce all of the materials to Irvin, Marriott removed the lawsuit to federal court. Since this case was no longer in state court, Marriott did not have to comply with the state court's order to produce the surveillance footage and other materials to Irvin. Nevertheless, Irvin's attorney, Levi McCarthan, was furious. He told the Dallas Morning News that he was, quote, mad as hell that they're hiding this stuff that is so relevant to my client's livelihood, end quote. He told the Dallas Morning News that I think it's terrible they're doing that. I don't know what's on the video. None of us have gotten to see it, but I sure think that at a minimum, Michael has got a right to see the video. And I certainly agree with him there. But the question is not, does Irvin have a right to see the video, but when and how soon does he have a right to see it? And that's what the current dispute is over. On February 22nd, Irvin filed a new motion in federal court for expedited discovery. Let's take a look at highlights from that motion. So here you have Irvin's new motion for expedited discovery filed in federal court in the Eastern District of Texas, U.S. District Court. Let's look through some of the highlights. It says in paragraph 1.03, to this day, despite numerous requests from security, hotel management, and other representatives of defendant, Irvin still does not know the who, what, when, or where of the allegation levied against him. I would also say he does not know the why. Why did they try to accuse him of this if their accusations were in fact false? Were they simply just trying to cancel him? And if so, to what end? Why? That's certainly a question that I'd like to have an answer to. Then in paragraph 1.04, it states that after suit was filed, Irving again sought copies of the footage from defendant in the form of a preservation of evidence letter attached hereto as Exhibit A. Again, Irvin was stonewalled and denied a copy of the very footage that would demonstrate the alleged misconduct by Irvin. On February 20th, 2023, the date that defendant's discovery responses were due, defendant filed its notice of removal, essentially nullifying the state court's order. Along with the notice of removal, defendant served its response to Irving's improper expedited discovery requests, and then they attach that as Exhibit C to this motion, and go on to state that through baseless objections, defendant once again denied Irvin the opportunity to view and witness the very footage that was used to evict him from his hotel room and was the basis of defendant surreptitiously accusing Irvin of misconduct to the NFL, resulting in his suspension from the NFL network. Then in paragraph 1.07, it states, Irvin now before this court once again asks that he be granted the opportunity to conduct limited expedited discovery related to the security footage of the hotel on the date of the incident so that he, the NFL, and anyone interested in the truth will be able to witness Irvin's conduct, judge for themselves, and cease the harm inflicted on Irvin each day that these defamatory allegations are allowed to persist. That right there is a powerful paragraph, and it is interesting because it does indicate that Irvin intends to actually release the footage to the public once he receives it. Then moving on down here at the bottom of the page, it states that despite Irvin's diligent efforts, he has been unable to ascertain who specifically made these allegations to the NFL and why they were adopted to the NFL without any further investigation by defendant. That is an excellent question. Those are two excellent questions that I am also wondering. Then moving on to paragraph number 2.04, it states that the fact that defendant reported the incident to the NFL and then refused to follow up on its investigation is extremely peculiar given defendant's harassment prevention policy. Marriott's policy requires a prompt and thorough investigation of all harassment complaints. Harassment complaints and investigations are, to the extent possible, strictly confidential. Information concerning harassment complaints and investigations is shared internally or externally only with persons who have a legitimate need to know. That the policy goes on to claim, as a result of Marriott's respect for all culture, most harassment complaints that the company receives are promptly and effectively investigated and resolved at a very early stage. Unfortunately for Irvin, this meant ignoring eyewitness statements and refusing to take remedial action. It accuses the Marriott Hotel of refusing to reopen its investigation or correct the wrong inflicted upon Irving, forcing him to file the lawsuit, even after it heard from the 3 witnesses, including the 2 TMZ witness interviews that we heard in my last video. Even after it heard that evidence, Marriott still refused to reopen the investigation or consider those witness statements. In paragraph 2.06, it states that the NFL has indefinitely suspended Irvin, and defendant's actions and refusal to release requested information have made it impossible for Irvin to clear his name. So I was honestly surprised that the NFL has indefinitely suspended Irvin. It then goes on to say that Irvin has been forced to cancel personal appearances with Cigna and PepsiCo, among others. Moreover, Irvin was forced to cancel his Michael Irvin charity football game, an appearance for the Wounded Warrior Project, a charity that supports veterans wounded in combat. Then it states, defendant is the only party that is delaying a proper investigation, and the timing of its removal is clearly indicative of its desire to outmaneuver the state court's order to rather than provide the requested footage. The burden on defendant is minimal, as the video should already be in a viewable format. Defendant took it upon itself to report misconduct to Irvin's employer. It is only just and equitable that defendant provide the evidence of this misconduct to Irvin and his employer now. The NFL Combine, where prospective football players go to demonstrate their talents in hopes of being signed or drafted, is scheduled for 2 weeks from now. Irvin is currently expected to work during the NFL Combine, presumably for the NFL Network or ESPN, but he will likely be removed from his role if defendant is not made to turn over whatever alleged evidence of misconduct that they have in their possession. Now, one thing I wanted to draw your attention to here is that in Irvin's federal motion for expedited discovery, he cut out all of the interrogatories that we saw in the state court motion and has narrowed his request down to this one request for production. He seeks any and all video recordings, written reports, and/or witness statements gathered that pertain to Michael Irvin's stay at the Renaissance Phoenix downtown hotel in February 2023. That's all he's asking for. In the final paragraph here, 4.02, Irvin requests that the expedited discovery be produced no later than Friday, February 24th at 5 p.m. Then, when February 24th rolled around, the federal court actually entered an order regarding Irvin's motion for expedited discovery. Let's take a look at it right now. Now, as you can see here, on February 24th, the court entered an order that states that defendants, that would be Marriott and Jane Doe, shall file a response to Michael Irvin's motion for expedited discovery no later than February 28, 2023 at 5 p.m. If no response is filed by that time, the court will take up the merits of the motion. So it's clear from this order that the judge understands the urgency of getting the surveillance video out there and produced to Irvin so that he knows what he's being accused of. And the judge is threatening to go ahead and rule on Irvin's motion, presumably grant it, if the Marriott does not file a response with valid, legitimate arguments for why that video should not be produced immediately to Irvin. So you might be wondering, what is Marriott going to do when its February 28th, 5 p.m. deadline rolls around? Based on my experience, I do not think that Marriott is going to just hand over the surveillance footage to Irvin on February 28th. Companies in most civil cases have all of the evidence that the plaintiff needs to prove their case. That's the case here with Marriott having all of the witness statements, having access to the employees who were involved in the matter, and having the surveillance footage. Irvin has none of this, and so he doesn't even know some of the details like the name of his actual accuser. So what is Marriott going to do on February 28th then? Well, I fully expect them to file a response in opposition to Irvin's motion for expedited discovery of the surveillance footage. Here are some of the objections that I believe Marriott's lawyers are going to make to producing the video to Irvin this early in the case. First, I expect that Marriott will object to the production of the surveillance footage on the ground that Marriott must protect the privacy of the Jane Doe employee who is presumably depicted in the surveillance footage, with Irvin, as well as the privacy of any hotel guests and other staff members who might appear in the hotel surveillance footage that Irvin has requested. Marriott will probably withhold the footage until the court enters what's known as a protective order that will, at the very least, require that the faces of any other guests or employees and the Jane Doe defendant be blurred out before that footage is produced over to Irvin. Marriott may also argue that good cause does not exist to force it to produce the surveillance footage to Irvin sooner than the rules of civil procedure require. Now, typically, courts have found that good cause for requiring a party to respond to a discovery request like this if the court is concerned about witness tampering or that evidence may be lost or destroyed. Those are usually good cause for an expedited discovery. In other words, earlier than normal discovery like Irvin is requesting in this case. Irvin's motion cites a New York federal opinion where the court allowed early discovery because the plaintiff produced evidence that the defendant had attempted to pay witnesses to give witness statements that were presumably false. Marriott may argue here that there is no risk of the surveillance footage being lost, stolen, or destroyed since it's saved to the cloud as a digital file, or whatever the case may be. Therefore, the argument goes, the court should deny Irvin's motion for expedited discovery, and Irvin should have to wait until the actual discovery deadline for producing that material, that surveillance footage, hits, just like defendants in every other case. In my opinion, that's an unpersuasive argument in this particular case. However, because if the footage vindicates Irvin, Marriott can prevent further harm to Irvin's reputation. Now, at the absolute latest, Marriott will have to produce a copy of the surveillance footage to Irvin by March 27th, 2023, this year. Where am I getting that date from? Well, I'm actually getting that from another order that the court entered on February 24th, in addition to the order requiring Marriott's response on February 28th. Let's look at the court's order governing proceedings. So here we have the court's February 24th order governing proceedings in this case. And as you'll see right here, it says this order shall govern proceedings in this case. The following deadlines are hereby set. Rule 26F Attorney Conference on or before March 17, 2023. We'll talk in a second about what that means. And then right here, this is the most important one of all. This is the court's order that the parties complete initial mandatory disclosures by March 27, 2023. Here we have Federal Rule of Civil Procedure 26. And then if we look at A1, this sets forth the initial mandatory disclosures. In the Irvin case, the deadline for making these disclosures is March 27, 2023. So what information must the Marriott produce to Irvin and vice versa in this case? Well, by March 27, 2023, Marriott must produce or disclose to Irvin the name and, if known, the address and telephone number of each individual likely to have discoverable information. That means knowledge about what happened. That would include any guests or witnesses that gave statements to Marriott in Marriott's investigation of this incident. And then along with the subjects of that information. So Marriott has to actually describe what the witnesses know. And then right here, it states that Marriott must also produce a copy or a description by category and location of all documents, electronically stored information, and tangible things that the disclosing party has in its possession, custody, or control and may use to support its claim or defenses unless the use would be solely for impeachment. So that would of course include for Marriott the surveillance footage that Irvin so desperately wants in this case, along with any witness statements that they were able to collect, documentation of the incident, an investigation report and findings potentially, and anything else that Marriott might use in its defense to the defamation claim. If you don't want to miss any updates on this case, make sure to hit that subscribe button below and turn the bell notification icon on. And of course, as always, thank you for watching.